Welcome to the Probate Nation. My name is Richard Ruddy and I am the host of the show. Probate is a process to transfer the title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. As we learned earlier in programs on fiduciary litigation and on the program Is This a Will?, getting started on your probate journey can sometimes prove to be a challenge when you seek to admit a will to probate and get qualified. Or, once you get qualified, you may encounter disputes as to the provisions in the will admitted to probate, or how the executor is handling the estate, or to a host of other matters. The resolution of these probate disputes is often done in a courtroom under the oversight of the local circuit court and can take considerable time and be very costly. Our show tonight takes a look at two widely used alternatives to resolving these disputes outside of the courtroom, namely mediation and arbitration. In our show, we will learn why these alternatives have become so popular, how they work, what types of fiduciary disputes are now being mediated, who mediates these disputes, and much more. We are very fortunate to have with us tonight two retired Fairfax County Circuit Court judges who have presided over and ruled on many will, probate, and fiduciary cases in the course of their judicial career. They will share with us some of their thoughts on the advantages and opportunities of using mediation or arbitration to resolve probate disputes. Judge Alden previously served on the Fairfax County Circuit Court for 16 years. Hearing all kinds of criminal and civil cases, including fiduciary disputes. While on the court, she served as the liaison with the Office of the Fairfax County Commissioner of Accounts, who oversees all estates being probated in Fairfax County. Formerly a full-time faculty member at her alma mater, the George Mason University School of Law, she now devotes her professional time to alternative dispute resolution with Judicial Solutions, PLC. Judge Wooldridge, since 2008, has been a mediator with the McGammon Group, helping resolve disputes of all kinds involving probate matters, trust in estates generally, and guardianships. Prior to 2008, he was also a judge on the Fairfax County Circuit Court for 16 years, hearing civil, family, and criminal matters, and serving as that court's liaison as well to the Commissioner of Accounts and to the Trust and Estates Bar. He also previously taught at George Mason Law School. Welcome. Thank you both for joining us today.
Thank you for having us.
You guys have had a stellar judicial career and have heard all kinds of cases over the course of your career involving fiduciary matters. Tell us a little bit about some of those cases that you've heard as judges on the circuit court.
Well, Richard, as you mentioned, probate always starts with the clerk of the circuit court. The clerk makes the initial decision, excuse me, about whether to admit a will to probate. Mm-hmm. But if there is a contest over the will or a dispute about whether it ought to be probated, that's when it comes to the circuit court, and a circuit court judge will resolve it. The kinds of disputes are as varied as the kinds of facts involved in every case. A common area of dispute is a question about whether the decedent had testamentary capacity, mm-hmm. whether the decedent understood the extent of his bounty, his natural takers, and if he understood that he was giving away his estate at the time that he made his will. Okay. Another area of dispute is whether there might be undue influence over the decedent in an effort to coerce the decedent to leave the estate in a certain way.
Very much so concerned.
Sometimes there's questions about the identity of the beneficiaries. For instance, if the will gives the estate to the children, does that include afterborn children? Does that include children born perhaps from another marriage or mm-hmm. prior to the time that the will was executed? So there's all kinds of questions that come up regarding capacity to start with.
Okay.
We also would sometimes see disputes regarding decisions that an executor or an administrator made. Some wills are very specific on what the executor may do or must do. Some wills give that executor a good deal of discretion And either one of those can lead to quarrels over whether that executor has done what he's supposed to do or followed the provisions in the will. We often also see disputes over powers of attorney that are made later in life, perhaps replacing an earlier power of attorney, perhaps changing the individual who's going to be responsible for decision-making regarding a person. Mm-hmm. We see disputes over wills that are made later in life. And Leslie, Judge Alden mentioned about testamentary capacity, the ability to make a will, and sometimes wills made later in life change who's going to be the beneficiary, and that doesn't always sit well with people where the change adversely affected them. So we can see a lot of disputes arising out of those as well.
Okay.
The court is often asked to interpret the meaning of a will. Words used in one will could have a certain meaning. They may not be the same meaning that words used in another will, because each case is determined on its specific facts. And the court is always looking to determine what is the intention of the testator, of the decedent. That's always the goal of the court, to try to determine that. First, from the very words that the decedent used in the will, mm-hmm. and if there's ambiguity, then by considering other circumstances that surrounded the execution of the will.
Okay. Judge, how long does it take to actually get a fiduciary dispute, to trial?
Well, in Fairfax, Judge Wooldridge knows, we always prided ourselves on the idea that we would resolve a case within a year of the time that it was filed. But these cases always start out with the clerk of the court. Sometimes they go through the commissioner of accounts. And so it can be a very lengthy process. Also, in other jurisdictions that don't have as many judges as we had in Fairfax, and other places in the Commonwealth that are not as staffed in the courts, it can take years sometimes to resolve these cases.
Goodness gracious. Apart from the time, and the cost of litigation, Judge Wooldridge, are there any non-financial costs that come into consideration in fiduciary disputes?
Yes, and I don't want to minimize the financial cost as well, because it is significant. It costs far more than people would expect or hope to get a matter tried. And usually that comes out of either their pockets or out of the estate, which kind of is the same thing sometimes. But the non-financial costs can be just as significant. Usually you're talking about families, parents, children, siblings that are in disagreement over a particular matter. And if a relationship between or among them was difficult before litigation, it's going to be doubly so after.
So true.
And if the relationship among them was a good one before litigation, the chances of it being good afterward are not great. So I don't know of any area that cries out for trying to resolve things apart from litigation any more than trusts and estates do, because it involves non-financial consequences to everyone that they all ought to try to avoid.
Sure, I couldn't agree with you more. And I know in recent years, lawyers have turned to this alternative dispute options in order to deal with these things on different levels. And so let's take a look at that. Judge Woodward, what is mediation? Tell us a little bit about that.
Mediation is generally a voluntary process. Sometimes courts order people into mediation, but not very often. So it's usually a voluntary process where a trained mediator, sometimes a retired judge, not necessarily, meets with the parties and their counsel to try and enable them to resolve things themselves. The mediator doesn't decide the case. The mediator tries to facilitate a resolution that the parties reach, help them determine what's really important, what their real needs are, find some areas of agreement, some areas of flexibility, some compromise, be creative in ways that a court isn't allowed to be creative, and try to help the parties with the help of this mediator reach some resolution to avoid the financial and non-financial toll that litigation does take.
So to contrast that with mediation, there is this thing called arbitration, Judge Aldrin. Tell us a little bit about how that plays into this.
Well, arbitration is also a dispute resolution process that takes place outside of court. It's a little bit more formalized than a mediation, and it can be either binding arbitration or non-binding arbitration. Usually it's binding arbitration, which means it's a final result. But the biggest difference between mediation and arbitration is that in arbitration, the arbitrator or a panel of arbitrators makes the ultimate decision about how to resolve the case. In other words, the arbitrator makes the decision about the resolution, not the parties themselves. In mediation, it's the parties themselves that have to come to an agreement. So when a party decides to arbitrate a matter, they're agreeing to submit the decision to be made in the case to the neutral.
Okay. Well, let's talk about, what are some of the reasons, why alternative dispute resolution techniques like these are so helpful? Judge Woodridge, why are these so helpful these days?
Well, in trust and estates cases, you're often dealing with clients who are infirm or elderly or sometimes deceased if it's a will that's involved. And the family dynamics that come into play there are not unlike those in other family cases like a divorce. And I think both Judge Alden and I, from our experience on the bench, think the courtroom's not the best place to resolve those. It's not the ideal place to resolve those, and resolving them in some other form is much better. You have the wishes of a decedent, for example, or someone who has made a power of attorney, and those wishes may not always be consistent with the expectations that the rest of that family has as to who's going to be the beneficiary of will or who's going to oversee a power of attorney. So there are a lot of emotional barriers to resolving things. We're talking about issues that are really best resolved by the parties themselves if they can possibly do so, rather than having a resolution forced upon them by a court.
Well, and as Judge Wooldridge mentioned, often the parties are infirm or incapacitated in some way, which makes it difficult for them to participate in court proceedings. There are also evidentiary problems that these kinds of cases have to deal with when they're in circuit court. We have something in Virginia known as the dead man statute, which may limit the type of testimony that can be admitted against a decedent in a case. There are also a lot of evidentiary burdens that come into play in these kinds of cases. For instance, if a party is alleging that the testator was overborne by undue influence, well, that burden of proof is by the greater weight of the evidence. So it's a high standard that the evidence has to meet. So if a party takes one of these cases to court, these are very technical, strict, and limiting legal parameters that have to be dealt with. If the parties decide to go to arbitration or mediation, those types of limits are much less onerous on the parties.
Okay.
But there are lots of other reasons why ADR, alternative dispute resolution, is good in this type of case and any type of case. For instance, with mediation and arbitration, parties can pick their mediator. So they can select a person or group of persons who might be knowledgeable about the legal issues in that field or just have experience in that area of the law. And they can pick someone who they rely on, who they have confidence in. They can be very flexible. Parties in ADR are not limited by court calendars. As you know, being a lawyer, the courts like to tell the parties when they're going to litigate and under what kind of a schedule they're going to operate. So if parties go to ADR, they can make their own schedule. It's much less expensive, as Judge Wooldridge mentioned, because there are fewer legal technicalities that have to be dealt with. Legal fees can be kept at a minimum. And there's a lot more flexibility. The parties can choose when and how they try to make their resolution. But, you know, maybe one of the most important things is that when parties go through arbitration or mediation, they're doing that privately. As you know, everything that happens in circuit court is a matter of record. It's open to the public. So these types of disputes, which are often involve very intimate details of families and parties, if you're in court, that's open to the public. If you're resolving your dispute outside of court, you can do it privately.
That can be very, very important. Well, let's talk a little bit about, you know, how mediation arbitration really works. You know, Judge Woodridge, you know, tell us about how one would go about mediating a common probate dispute. How does it really go from start to finish?
Sure. As Judge Alden suggested, it's a much less formal process than the courtroom is. It's often held at an attorney's office or at some neutral site. Usually starts with everyone in the same room and the mediator leading the discussion and the presentation. Each counsel, and often the parties, gets an opportunity to have their say, to say what's on their mind. Then they're probably in separate rooms for most of the rest of the day with the mediator going back and forth. Sometimes they'll reconvene as a group if the mediator thinks that's what's most helpful, but usually they'll spend most of their day apart from one another. The length of the mediation really depends on the complexity of the issues, the number of issues, the number of parties involved. It certainly often takes the better part of a day. Sometimes it's a multi-day process, and you may do it 2 or 3 days in a row. You may do a day now and do a day a few weeks later, do a day a few weeks later after that. The goal through all of that process is for the parties to reach an agreement, to memorialize that agreement in some fashion, have them sign it, and then that can be presented to the court to avoid the litigation that you are trying to keep people away from.
Okay. So let's take arbitration, Judge Alden. How does that, just walk us through kind of how that process works in contrast to mediation?
Well, the parties will select an arbitrator or panel of arbitrators. Usually in these kinds of cases, it's a single arbitrator. Who will then meet with the parties. They'll discuss a schedule, how they would like to proceed, whether there would be any discovery and the rules under which that would operate. It's all handled outside of court, but it can be as formal as the parties would like or as informal as the parties would like. So they will select a date to have a hearing. There may be an exchange of memoranda on the legal issues. There may be an exchange of exhibits that each side intends to bring in. But it's very much handled like a trial, except it's outside of the rigors of the court and the rigors of litigation rules and evidentiary procedures. But it very much will be a final decision by the arbitrator.
And so I know that we've talked about this, that some cases will start in mediation and then they will get converted to arbitration because maybe the parties can't agree. Have you seen that happen?
That happens, and I think that's a fine process because the parties initially hope that they will be able to resolve it amongst themselves, and they work very hard to do that. But if it happens that they can't ultimately reach a decision, then either they can select the mediator to act as an arbitrator, or they can select a new neutral who would come into the case then and finally decide the issue for them.
Okay. Well, I know we've talked during the course of our interview about the different types of things that the common fiduciary disputes that would be handled through mediation arbitration, whether it's second marriage conflicts or interpretation of will provisions, or disputes about among beneficiaries, as far as them thinking they're entitled to something and they're not going to get something, especially children, or decisions by the executors or the administrators. But I think we're going to move on to, I think really the important thing is, I think at this point is, let's talk about what are the qualities of this person that we're going to select to be the arbitrator or mediator. What are the qualities we're looking for in selecting someone like that to help us sort through something and preserve the family relationships?
Well, it has to be someone who really wants to help people, who likes to help people solve their problems, particularly in the case of a mediator, because what a mediator does is facilitate the communication and the discussion and helps to let the parties bring around a resolution on their own. So it's someone who has to enjoy doing that and who gets a benefit out of helping people resolve problems and sometimes very personal and long-standing issues going on in the family maybe for generations in the past and perhaps generations in the future. Someone who has to be very patient and empathetic and understand that in these kinds of cases, parties really need to work through a lot of emotional issues and family issues, and sometimes, as Judge Wooldridge mentioned, that takes a lot of time. It doesn't happen in a day or one day, or it may take a little while to get it resolved.
Yeah, I think the willingness to take some time and work with them is important. I think the mediator is going to want to have some knowledge of the subject area. There are some disputes out there that I won't mediate because they're in a field of law that I just don't have any familiarity with. Something like trust and estates, Judge Alden and I do, so I'd be more comfortable mediating those. A mediator sometimes is asked by the attorneys to be evaluative during the course of the proceeding, to tell the parties not what's going to happen in court, because nobody knows, but based on his or her experience, what often happens in relation to these matters, to try and help the parties be more realistic about outcomes. I think that the mediator has to be neutral and have the right temperament for that, but also, when the time calls for it, be willing to try to encourage or nudge the parties to some resolution that might settle this case based on what he or she knows from the other room, or some resolution that might be more consistent with what's going to happen if they go to, what's likely to happen if they go to court. So I think you want to help the parties understand the realities of what litigation may bring.
And what Judge Wooldridge just said is so important, because we never know what's going to happen in court. And as much as we know the environment of the legal community, as much as we know about judges and what they normally rule, how they view cases, the reality is every litigant walks into a courtroom not knowing what the result of that case is going to be. And the beauty of ADR is that a party can eliminate all of that risk and uncertainty and emotional turmoil that goes along with that by resolving the case themselves.
I think that's very, very true. I know, especially, the technical evidentiary process, how we actually get stuff admitted to evidence can sometimes derail even the best of cases.
Well, it can, and of course judges always try to make the right decision, but there are some areas of the law that are undecided. So a court can make a decision, an evidentiary decision or some other technical decision that can send a case off a certain way. Maybe the judge is wrong, and that ultimately has to be appealed, but all of those things add a great deal of uncertainty and cost to a case that really at the end of the day ought to be decided by the parties anyway.
Well, Judge Wooldridge, how does mediation or arbitration get started?
Typically, the parties, through their counsel, will request, ask of the other side, are you willing to mediate this matter? And if they are, then they contact a mediation service, and they can ask for a specific mediator, or they can ask who's available, who has some experience in this area. And the cost that's associated with mediation is typically borne by the parties, shared in some fashion. Sometimes, if the parties are not on the same even financial keel, one side may bear more or all of the cost of the mediation, subject to being divided later on. You're really talking in terms of costs about the mediator's time, because you're likely paying a mediator for his or her time, and the cost of your counsel's time. But hopefully the second of those is a lot less than the cost of your counsel preparing for trial. Preparing for mediation is going to be a lot less financially costly to the parties than preparing for trial would be.
Of course. Well, we've covered a lot of material. It seems like time has just flown by. It just seems like arbitration and mediation is just such an effective tool to help people sort through problems, and I think, as you both said, keeping families together, because frequently we're talking about issues that probably could be resolved. They just maybe need a little bit of a nudge. But how about you taking some time now to share some of your final thoughts about mediation, arbitration, and its role in resolving fiduciary disputes?
Well, today we're dealing a lot with a lot of blended families and subsequent marriages, but we're really talking about family dynamics, which is very important. And I think it's never too early for parties involved in these kinds of disputes to talk to their lawyers about the possibility of an alternative resolution outside of court. I think from the very beginning of the case, and it may be incumbent upon the lawyers really to explore those options with their clients from the beginning. Now, sometimes the beginning's a little rocky and people aren't automatically thinking about resolution right away. But before too long into the case, they're going to start thinking about the time this is costing them, the legal expense it's costing them, the disharmony within the family. So it's never too early to start thinking about it, and then when the time comes that both sides can agree, now is the time to try to do this, they can be ready to go.
And suggesting mediation is not some sign of weakness. It really is a recognition of the realities of what you have and the financial cost and toll and the emotional toll that it can take, especially on families. I think parties, as Judge Alden suggested, are well to consider that early in the process rather than late.
I couldn't agree with you folks both more. Judge Alden, Judge Woodward, I want to thank you both for taking this time to share, your vast experience both from on the bench and now in private practice as mediators and arbitrators. It's a great public service you've provided to all the folks across Northern Virginia.
Well, it's very important,
you.
Richard. Thank you for having us.
My pleasure. Thank you for coming. You would think it would be easy to get started on your probate journey, with a quick trip to the local probate office with mom's will in hand. And when that is completed, off you go on your probate train ride. Yet, as we learned in earlier programs, there are many challenges that can arise, beginning with getting what you think is the last will of your loved one admitted to probate, or disputes over the interpretation of a provision in that will, or how the tangible assets are divided among the children, or questions about the executor's actions in the course of administering the probate, and on it goes. Often these challenges end up being sorted out through litigation and rulings by the local court, and this takes time and is typically very costly. What we learned today is that there are alternatives to litigation, namely mediation and arbitration, and these alternatives provide a host of benefits when compared with litigation, including more informal, less stressful environments, an opportunity to participate in reaching a resolution, often a faster resolution, and less costly in terms of legal fees and other costs. But importantly, it may provide a means to resolve a dispute without permanently damaging the relationship between family members who may be on opposite sides in a probate dispute. If you find yourself in the midst of a probate or estate dispute, I encourage you to reach out to an attorney who is experienced in litigating fiduciary matters to get advice and guidance, and discuss with them early on whether mediation or arbitration might be appropriate if the matter cannot be settled. This brings us to the conclusion of our show today on mediation and arbitration of probate disputes. I hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.